And we have a final case set for argument this morning. State of Ohio versus Trevor White, case number 18CA011305. Both parties are present for the argument. So each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve time, let me know and I'll keep track of that time for you and let you know as you're approaching your rebuttal time. The oral arguments are recorded, so we ask that you stay at the podium, the front podium here, and keep your voice up so that we can get a good recording of you. I can't remember if there are children involved, but if there's children or victims, we prefer that you use initials as opposed to names. Other than that, we've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. May it please the court, Attorney Brett Myrna, 0074363, on behalf of the appellant. I would ask to reserve 4 minutes for rebuttal time.
All right, I'll let you know as you approach that.
Thank you for my presentation. As the judge has said, you've read the brief in this matter. This is a one-issue appeal. Did the trial court abuse its discretion in denying appellant's motion to withdraw a guilty plea? Facts of the matter are laid out in the brief of appellant. Appellant was charged with some very serious crimes, murder, multiple counts. At some point through his trial counsel, he entered a plea agreement was reached and a sentencing hearing was conducted. This was in front of trial judge Giraldi. Also, as kind of, I guess, the current custom and practice in this particular court, they have a list of plea sheets, I guess is what they call them.
So there was a written plea of guilty here?
There is in those plea sheets.
Okay.
Correct. And in those plea sheets, the various constitutional protections and admonishments that one would normally move forward with, both orally from a judge, are written down, the kind of the standards, right? You have the right to a jury or bench trial. You have the right to get the case proven beyond a reasonable doubt against you. You know, a lawyer, if you can't have a lawyer, will defend this for you. Various of those things that have been well litigated and are in fact.
And the defendant signs it?
Defendant signs it, yep. Defendant signed it, they go on the record. The judge goes through some of those, but not all of them. If you look at the record, there's no mention made of a jury or bench trial. I didn't raise that in my briefs, but I think it does show the point that they didn't go through each and every sentence in that particular
Did you raise those issues in your motion to vacate?
My motion to withdraw plea, yes.
I'm sorry, yeah. About the judge didn't go through all of his rights? Did you raise those issues, or did you rely solely on Kubison in your
Solely
motion
on
to
Kubison.
Okay, thank you.
I'm just sort of setting the stage for, and I'm certainly aware of Judge Callahan, Judge Carr as two of the writers of Kubison, which is, we can skip right to that, yes.
Why don't we skip right to that?
Great. This is Kubison. Same judge, same language.
Can I ask you a question? I know you quoted from the Kubison opinion. Did you ever read the entire Kubison transcript?
I did.
You don't see differences?
I do not in that, the guilty plea was never elicited in Mr. White's.
I would say you would agree with me that this is post-sentence, but I think part of your argument is that it should be treated as pre-sentence, correct?
It can be post-sentence, and I do agree with you that there is a nuance there, but the post-sentence withdrawals, I think, should have been denied on a timely manner, not on a compliance with Criminal Rule 11 manner. If you look at Judge Giraldi's, and it's attached to my brief, sorry, my pacer,
I am too.
So is he.
trial attorney, what you did, I will tether myself. The denial is based solely upon requirements and substantial requirements of Criminal Rule 11. Of course, in a criminal Rule 32 motion post-sentence, there is that timely issue. There are some of those further concerns.
Can you explain to me what the manifest injustice is here?
The manifest injustice is at a structural and constitutional level. Don't we need to ensure that all pleas, the word guilty is said, we have to comply with those things.
And is there any argument that your client didn't knowingly, voluntarily enter that plea?
On the knowing and voluntarily, I think he knew where was going on there, but I think we need to have the magic language, basically, if you have to plead guilty to a felony, the words need to be out there.
Did his attorney enter a plea for him in this case?
I think it can be construed as that.
Okay.
I don't know. That page, I guess I could look through it, was certainly by custom and practice. I think he indicated that, yes, we've gone over these plea sheets. This is what we wish to do. Things along those lines. I don't know that the attorney actually said, I hereby enter a plea of guilty on behalf of my client. Okay. So as we would move forward with that, and I appreciate the questions, Judge Callahan. Yes, I would say Kubison should be extended to this situation for post-sentence withdrawals. I would submit that stare decisis controls here, and that this isn't analogous facts. Certainly, I would say the language is the exact same language, and I am sure this judge used it. I haven't had a lot of trial level with this particular judge, but I think it's fair to think that's, most judges use a standard kind of, when you take a plea, you've got a script, if you will, right? And if it was faulty then, it's faulty now, and it needs to be, for all of those cases. So there might be more behind me. I don't know. I was just involved in this particular one. But if we feel that Kubison is still good law, then it should be extended to post-sentencing, I guess, as well. Additionally, I think I'd argue maybe, now that I'm thinking about it, maybe Kubison was sentenced as well, right? Didn't he immediately get put into diversion?
That's not a sentence.
Arguable. I mean, but there was a
It was an
consequence.
intervention case.
It was an intervention, I'm sorry, you're right. But there was a consequence of the plea, right?
She gets asked the questions.
Oh, sorry. I thought it was an interesting thing. I apologize, Judge.
That's okay, I just.
But I guess I would
I'm
submit
only
that there
saying
was.
that because since the state appealed, I don't know how far it went, because that was the state's appeal.
But I would submit to the court that in the Kubison case, that after the plea is placed into the intervention program, which is part of the sentencing, I know the court technically holds sentencing in abeyance, but if one fails the intervention program, then that guilty plea is activated, and then we move on to the sentencing. So it's probably a little bit of a gray area there, but there was certainly a consequence to that plea, meaning he would have been placed under court supervision as a direct result thereof. So while there was no jail time, no formal probation placed on there, I think I would submit to the court that the conditions of the diversion program or intervention in lieu of conviction are akin to a probation, meaning that if one does not follow through with them, there can be negative consequences, probably closer to community control than an actual prison sentence. I would also, the state in their appeal brief, or appellee, excuse me, argues that the court's reasoning isn't sound in the Kubison decision, and makes some argument that I guess they would like to revisit it because that was an issue actually brought forth by the court itself. I don't think it was raised in Mr. Kubison's direct appeal, I believe. You, Judge Gall, I think you were the writing of the Kubison decision, saw that, reviewed the transcript, and moved forward with that. I don't know how relevant that is particularly to this particular matter, meaning that, if the state of Ohio wants to raise a collateral attack on a previous decision, there might have been another mechanism available, motion for reconsideration based on the way Kubison was decided, and to bring it up a year later does seem a little untimely to me.
Well, there's no requirement that they do that. I mean, they could still
see that, to a certain point, there's certainly the language is the same. The ramifications, I guess, of the language are different. But it does seem maybe a better vehicle would have been to, a motion for reconsideration or something along those lines.
Except that they got the case back in front of the judge on their intervention, so back then they wouldn't have wanted that reconsidered.
If the justices don't have any more questions, I would sit down.
You'll have 5 minutes for
Sure.
rebuttal. All right, say that's 15 minutes for your argument.
Good morning, Your Honors. Lindsay Poprocki on behalf of the state, the appellee in this matter. As the appellant has indicated, this appeal stems from the trial court's denial of his motion to withdraw his post-sentence guilty plea.
Well, let me just start right there, because like Judge Callahan said, we're all pretty familiar with this. So I read your brief to say that you're basically saying that Kubison was wrongfully decided.
Correct.
Okay. So I guess what I'm wondering is, if Kubison was wrongfully decided, well, of course, as Judge Callahan said, you wouldn't have any reason that you would have objected at that point because of the nature of that case, but I'm just wondering, so with your point of view, then it would have been a guilty plea on the basis of the written statement, the written entering of a plea. The plea would have been entered through the Rule 11 written statement.
In this matter.
In this manner, right?
Correct.
And the reason I'm asking that is because I think maybe this is more appropriate for opposing counsel on rebuttal, but what I was wondering is but I'll ask you too, if you don't, let's just say Kubison, because Kubison is our law right now.
Correct.
Okay, so under Kubison, if he didn't enter a plea, you have to enter an oral plea in court. How would it be post-sentence if you never entered a plea? I'm sorry, I went around and around.
Great. How would it be post-sentence if he?
Well, in
How
other
would
words,
this motion be before this court post-sentence if he didn't enter a plea? That was going to be my
oh, I'm sorry.
next statement, I believe. That his motion
I'm glad you
actually,
understood me.
his motion actually presupposes that a guilty plea was made. That would be my position on the fact that he has filed a motion to withdraw a guilty plea, is that the very nature of that motion presupposes that he actually made a guilty plea. And in assigning error to this court, he's relying on the Kubison decision, wherein this court said that because a guilty plea was not actually entered orally on the record by stating that the defendant, because the defendant didn't actually say guilty on the record, no guilty plea was entered. And the state wants to note that the issue raised in Kubison was done so sua sponte by the court, and that no party was given the opportunity to research or brief the issue. We think that's important because if we were to have been given the opportunity to research or brief the issue, we would have raised the issues and implications of Criminal Rule 11A, its interpretation by other appellate districts, and the effects that any applicable plea sheets would have been given.
But you made a calculated decision at that point with that case,
Correct.
because you
And-
got the result you wanted, and you just didn't like the reasoning.
And that's correct. And we discussed that, and as you indicated, the decision in Kubison allowed us to come back before the trial court on the intervention issue. And in our brief, we raised the issue of Criminal Rule 11, which we think is important because it distinguishes between pleas which must be made in writing and those which may be made orally. And specifically, Criminal Rule 11A states that pleas of not guilty by reason of insanity shall be in writing, and all other pleas may be made orally. And multiple other districts, appellate districts, including the 12th, 4th, 11th, and 10th, have interpreted this language to mean that while a defendant is permitted to make his guilty plea orally, he is not required to do so, as the criminal rules use the word may as opposed to shall. Accordingly,
Of course, we all know case law says shall means may and may means shall, who knows? You know, seriously, you have those cases.
right,
So go ahead, I'm sorry.
okay. So those cases stand for the proposition that the fact that a simple guilty plea may be made orally implies that it may also be made in writing. Here, White's negotiated plea was reduced to writing in plea sheets, which were presented in open court at the plea hearing. They were extensive and contained numerous instances where White either entered a plea of guilty or acknowledged that he was pleading guilty. White's retained counsel also acknowledged that White read the plea sheets and answered the questions and asked the court to accept his plea and asked the court to accept White's plea. The trial court then conducted an extensive colloquy with White, which referenced his guilty plea on numerous occasions. The trial court importantly then addressed the plea sheets with White and incorporated them and their answers into the proceedings. Upon inquiry by the trial court, White acknowledged that he signed the plea sheets, that he reviewed them, that they were explained to them, and that he understood them and signed them voluntarily. The court ultimately accepted White's plea to the indictment and found him guilty after finding that his plea was knowingly, voluntarily, and intelligently made. The state.
Is there a danger, though, in accepting a written plea of guilty that somebody other than the defendant, for instance, signed it and just submitted it to the court? There's, when the defendant isn't actually stating in open court that he's guilty. Is that a danger?
Is there a danger that?
Sure.
I don't think so when the defendant goes openly on the record and acknowledges that he in fact signed the plea sheet.
What if he was reluctant to enter a plea of guilty? And, sometimes it's difficult for defendants to make that decision and to speak up in front of when their attorney may think, the way to go is enter a guilty plea, but they want a trial. It just seems like there may be a danger there. I guess it would depend on the inquiry by the court.
I think that's exactly the answer, that it would depend on a factual situation, and in this case, there was no danger. The representation was made by the trial attorney that White had signed the plea sheets, and he asked that the court accept his plea, and White himself acknowledged the plea sheets in many different facets and acknowledged that he signed the plea sheets voluntarily.
Of course, when it's an open court, it does give the defendant an opportunity to second guess himself or to reconsider his decision. That's not given when a plea is just submitted in writing.
But here the plea sheets were incorporated into the oral plea. The plea happened both orally and in writing.
No, I understand your
It's not just a
argument in
matter-
this case. I guess I'm worried about what precedent we're setting as far as how far are we going to go. Are we going to next say you can fax in a plea of guilty?
I don't think so.
Well, in some jurisdictions, at least on misdemeanors, you can
On
send.
certain offenses, you
Yeah.
can, yeah.
Absolutely.
I'm sorry, I'm just thinking out loud here.
That's
Go
okay,
ahead.
that's okay.
And the thing is, I know we had the Kubison case and now this case, but that surely isn't standard operating procedure, is it, that you don't have the defendant, they don't ask the defendant, so what is your plea? I mean, do you just, and I don't know, I'm just asking because this is, foreign to the way it's usually done. Usually it is done, that even if you have a written plea, or in the Rule 11 assignment of rights and so forth, you still ask the defendant in court, how do you plea?
I don't know that the court in many different manners asks, do you acknowledge that you're pleading guilty? Do Do you understand that by doing what you're doing today, you're entering a plea of guilty? Is this your intent today to plead guilty? Yes, yes, yes. I think that the defendant's counsel's representation to the court that they're pleading guilty in all those different ways, they are pleading guilty when they enter their plea.
Other than saying I'm guilty.
I don't know that criminal rule 11 requires those magic words, and that would be the state's position.
Well, you'd agree it's the best practice, I would hope, to ask a defendant orally. Not that it's, I understand your position, it's not required.
It would be my position that it is not required. Those magic words are not required. The state is arguing that based on the permissive language of criminal rule 11A, and that it provides that a guilty plea may be entered orally. That's important, that a guilty plea may be entered orally. The proposition that by implication a plea may also be entered in writing must be given due weight and considered, especially based on the other appellate districts which have agreed that the defendant's legal acknowledgement that he knowingly and voluntarily signed a written plea agreement on the record is tantamount to orally entering a plea. Those cases are thus in conflict with Kubison. Here we would submit that the trial court did not abuse its discretion when it denied White's post-sentence motion to withdraw his guilty plea. A review of the record establishes that White entered a guilty plea to all charges in the indictment through written plea sheets, which were signed by White and adopted by the trial court after his trial counsel acknowledged and represented that White entered a plea of guilty. The trial court also engaged in a meaningful dialogue with White pursuant to Criminal Rule 11C, which White does not dispute. Granting a motion to withdraw a guilty plea is an extraordinary remedy. And White had to show that he suffered a manifest injustice before the trial court would grant his motion to withdraw a guilty plea. Here the trial court properly complied with Criminal Rule 11, particularly 11A, prior to accepting White's guilty plea, and White knowingly, intelligently, and voluntarily entered his plea.
Certainly he's not saying that he didn't.
No. And we would ask this court to again revisit Kubison and its decision therein, because we were not afforded an opportunity to brief the issue and explain the effects of Criminal 11A. The appellate districts who disagree with the rationale of Kubison and affirm the decision of the trial court denying White's motion to withdraw his plea.
Okay, I gotta go back to that. I thought you just had answered Judge Carr's question that was kind of a calculated, you talked and that was a calculated decision regarding Kubison. And
I'm
not
sorry.
filing any motion to reconsider or anything of that nature. Or did I misunderstand your answer to Judge Carr?
I was asking maybe I misspoke in that I was asking the trial court to affirm the decision of the trial court to deny White's motion to withdraw.
Okay.
Maybe I misspoke.
We probably, not that I'm gonna try to be the interpreter, but I guess I will.
I'm sorry.
No,
No,
the point is, I think you're saying that you didn't get an opportunity to, in the case itself, we raised this
Okay.
responding. Is that
Right.
what you're saying? But you
Right.
could have filed a motion for reconsideration.
But we chose not to do that. You're correct.
It wasn't an assigned error in the prior, in the Kubison case.
It was not an assigned error that was raised and decided.
Anything else?
Thank
Okay, thank you. 5 minutes.
In this particular matter, I don't think we're getting to, in criminal rule 11, there's certain, the constitutional provisions thereof are strict compliance, the non-constitutional provisions are substantial compliance. And I think Judge Carter hit it right on the head, there was no plea here. There's no valid plea, in that it wasn't put orally on the record.
Then how do you withdraw a guilty plea?
Right. I mean, I don't know, currently as he stands, he entered a guilty plea. There was a sentence, so I'm pretty sure that I would submit that the motion to withdraw a guilty plea was the proper vehicle at that point to try and get the plea withdrawn or vacated, meaning the court believed the document reflects that it is a plea, just that, we do have case law that seems very much on point, but it was still a guilty plea that needed to be withdrawn or vacated, and that was certainly the thought process behind the vehicle to get that done. One other thing, where's my notes? I apologize. Is very much so, I think, the open court aspect of any plea is certainly something any trial court should keep in high in their mind for the substantial and strict compliance of certain constitutional provisions. And I would agree with the court that it's certainly best practice for a person to say, how do you plead? I plead guilty, I plead no contest. I continue to do so. Unless the court has any further questions for me. Just give me 1 second.
Doesn't look like there are, so thank you both for your presentations and arguments today. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will certainly mail you each a copy of the court's decision once it is filed and released, and the Supreme Court of Ohio also posts the court's opinions on its websites. The court will be